afternoon. My name is Brenna Durden. I serve as the Special Magistrate for the City of Jacksonville Beach. This is the meeting of Wednesday, June 26th of 2024 for the Code Enforcement Agenda. The agenda has 3 items on it, and we will hear those after the clerk makes the general announcements. Thank you.
The purpose and function of the Jacksonville Beach Special Magistrate hearing in accordance with Florida State Statutes Chapter 162 and the City of Jacksonville Beach Code of Ordinances is to reach an equitable expedition to enforce codes. The city presents the violation and the evidence to the special magistrate. Next, the property owner is sworn in and responds to the violation and evidence. Both the city and the property owner may call witnesses to provide sworn testimony relevant to the case. This is a quasi-judicial hearing, not a public forum. Individuals not called as sworn witnesses will not be heard.
Thank you very much. If you will, Ms. Beavers, please identify yourself.
Please raise your right hand and state your name and address.
Nikki Beavers.
Do you swear or affirm that the testimony you are about to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
I do. All right. Seeing that only one of the respondents is here today, we're going to go ahead and follow the order of the agenda.
Okay.
We will be starting off with case number 23-130. This is for 1121 North 3rd Street. The violation was outdoor display, prohibited use for the business of outdoor advertising.
Could you repeat those again, please? Are these 341 and 342K?
Correct. This was a continuance from our May hearing. The city attorney and the planning and zoning director, the director is who interprets the code, and she's here to testify today from the continuance from our last hearing day.
Okay. I have a couple of questions.
Okay.
First, I just want to ask you about the notice of hearing that was sent on June 6th.
Okay.
In that notice, it says that on September 1, 2023, at 1112 North 3rd Street, that the respondent violated the City of Jacksonville Code. It's my understanding that you have observed a violation during 2024. For the record, could you please tell us what those dates were?
So, as you can see on the pictures are date stamped. The original case began September 21st. That was for the initial violation, and during that initial violation, that case was brought before the special magistrate, and it was ordered that they remain in compliance of not having any outdoor display. So this was a continuance of repeat violations, and that's why we're back here today.
I understand that, but could you answer the question about the subsequent observations?
Yes, so this right here, after that initial case was started in September, the next violation was observed after that hearing in magistrate order was on May 2nd, 2024. As you can see, it's pictured in these date stamp photos.
Okay.
And so my final inspection, which was on yesterday, June 25th, it shows that the property owner was in compliance. There was no violation observed at that time.
Okay.
right hand and state your name and address.
My name is Anton Patrick Poe.
Speak into
Mr. Poe, could you
Yes.
clarify for the record, or state for the record, who you're here on behalf of today?
Yes, my name is Anton Patrick Poe. I'm an owner of T. Gregory Imports. T. Gregory Imports is the business tenant at the subject property. So I only represent T. Gregory Imports, the tenant at the subject property that the underlying alleged violation concerns.
So,
There is a representative of 121 North 3rd Street, Inc., who is the respondent, and that is Rich Trindle. He's right there.
Okay.
So that's the entity that is the owner and landlord of the property.
Will both of you be speaking today?
Mr. Trindle is available to speak.
Yeah, if necessary.
Okay, thank you.
Mr. Poe, do you swear or affirm that the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I did. So I'd like to back up a minute. As I just explained, I represent T. Gregory Imports. And at the last hearing, which was on May 22nd, 2024, we went through the citation and presented some argument, and then Your Honor continued the case with an instruction, as I understood it, for the parties to schedule a meeting in the interim prior to June 26th with a recommendation that the parties try to reach some sort of amicable agreement. And I welcomed that approach and thought that we would have that meeting. So I reached out to Ms. Beavers on May 24th, and then I reached out again on June 11th, and Ms. Beavers responded on June 11th and said that she was out of town until June 17th, and that she would, when she got back on June 17th, would figure out scheduling for that meeting. And then I heard nothing until we're here today, and we seem to be moving forward as if that direction wasn't given. And I think still that a meeting of that nature would be beneficial. And I welcome that sort of meeting because I would like very much, as I said in the first hearing, to resolve this amicably. I maintain the position, and I know we talked about it a whole lot, but to sort of reiterate some key points, I maintain the position that the ordinance cited is not applicable to the circumstances at hand. And we argued that and made the point that the ordinance says the business of outdoor advertising. Now, whether or not a couple chairs and a sign by the business of the property constitutes advertising is a different question as to whether it constitutes the business of outdoor advertising. And it seems quite clear that the business of outdoor advertising is wholly distinct. The business of outdoor advertising would be selling advertising space, such as billboards and that sort of thing. So we presented that argument, and we said that the law does not apply.
If I may, Mr. Poe, you referenced that it may constitute outdoor advertising. What is that section that you're referring to?
No, I'm just saying, well, I'm not referring to a section. I'm saying, well, I'm not referring to any section. I'm saying that while somebody might argue that some things being outside might be advertising for the business. I'm not referring to a section. I'm saying someone might argue that. I'm not saying it is or isn't, but I'm saying clearly it is not the business of outdoor advertising, because the prohibited act, the ordinance that's cited, the ordinance that is the basis of the violation, says that it prohibits the business of outdoor advertising. And that would mean that there would be a situation where there's some sort of compensation. The business of outdoor advertising refers to receiving compensation from third parties for billboards, commercial advertising, or other promotional media of that sort. And it seems quite clear that that's all that the subject provision is intended to cite. Now, again, my understanding was that we were going to have a meeting with the city and try to see if we can come to some sort of mutual understanding of things. And I also understand that you had invited or asked Ms. Beavers to invite somebody here to talk about the city's interpretation of the provision. And with all due respect to everybody here, because I know everybody's just trying their best, the ordinance has to be strictly construed. It says exactly what it says, and no more. And so, whether or not, and Ms. Beavers explained that she believes that it encompasses the full gamut of anything that's outside that might be considered advertising. And that's,
What is your basis for believing that the code has to be strictly construed?
I believe that's pretty bedrock. I didn't bring a case citation. I think that's pretty bedrock case law, that the code sections should be strictly construed.
Most codes, and I'm pretty sure this one probably is the same, will have a provision in it that will say that they'll be liberally construed. And I would expect that this land development code also has a similar provision.
If it does, I didn't see that. I'm not saying it does or does not. I'm not aware of this. I'm not aware of whether this code provision has that. So I would argue that it should be strictly construed, and I'm not aware of whether it has a separate provision that it should be liberally construed. Even if it were liberally construed, it goes beyond the bounds of liberal construction to interpret that the business of outdoor advertising means a couple of chairs and a flag outside. And that's what the citation is for. The citation is for having a couple of chairs and a flag outside. And the suggestion that that constitutes the business of outdoor advertising is beyond liberal construction. The business of outdoor advertising, it means something completely different.
Okay, thank you.
There were a few other points that I would like to make, if I could.
Is it a repeat of?
No, I'm going
what
to
you
try
said
not to
in
be
the past?
repetitive. No, I would also like to point out that we, as Ms. Beavers indicated, since, and as I said I would, since the May 22 hearing, we have essentially complied with the demands of the city regarding not putting items outside at all. And it has been...
I took a clear note of that.
Thank you. But I would also add that it has been substantially detrimental to our business. We have customers coming in, asking if we're closed, saying, wow, I drove by and wasn't sure that you were open. And because
Have you actually had somebody say that to you directly?
I did not have some.
Is that you've been told that?
So, and I understand that this is a fairly informal hearing. I have been told that. So if you want to strike it on a hearsay basis, then I suppose you
No,
could.
I just want to be clear.
Yes.
Thank
My
you.
the manager of the store told me that several people have come in and pointed out that they thought the place was they thought the business might have been closed because it looks so different. Because
Excuse me, have you tried other ways to make sure that, to try to tell people or advise people as they're driving down 3rd Street that you're actually open?
So that's an interesting question. I'm not sure what other ways there might be. But the store has been in operation in that location for over 20 years and has functioned essentially that way with having items outside for over 20 years. And has had absolutely no problem or has not been accused of violating any ordinance as a result until last September. And then again, I suppose the violation that is at issue here on May 2nd, May 2nd. But, so to answer your question, sure, we have social media, we have a sign in the window that says open. We have other ways that folks could be aware that our store is open. We have our hours posted on the door. But as a historical practice, this store has regularly had things outside indicating that it's open and looking welcoming. And again, and as a matter of brand, this is one of 4 stores. We have a store in St. Augustine, we have a store in Fernandina Beach, and we have a store in Ormond Beach. At all 4 locations, and I have pictures, which I'll be glad to show you, we have some furniture outside, and that's kind of, here's here's the brand. Now, if needs to be a conversation, or if there could be a conversation about how much is too much, I was hoping that would be the discussion as part of the meeting that you had recommended. And I'm happy to have that sort of a discussion as a matter of some sort of compromise. But to the extent we're here as a matter of the law on a citation for a violation of a provision that says prohibition against the business of outdoor advertising, then again, it is our position that law is not applicable and no violation has happened. And it's not fair to start looking for other laws that we might have violated. If that's the citation, that's the citation.
I want to make sure you understand why I'm not going to accept into evidence the pictures of your other businesses, locations, because really it's not part and parcel to what we're here on today. If you have pictures of your current business, that additional pictures that you want to submit, that's fine. But I don't think it's appropriate or relevant for the other locations.
Then I'll submit, and I may have shown this picture to you before. Well, here, let me argue why it's relevant. I think it's relevant because, again, the alleged violation is about the business of outdoor advertising. And my position is that this is not a violation of the business of outdoor advertising. And further, it is being true to the brand, which is not the business of outdoor advertising. Having a few chairs outside, having a welcome sign that invites people in is part of the store's brand and is not the business of outdoor advertising. And so that's why I think that those pictures would be relevant.
And it's my understanding you purchased the business assets in late December of '23.
Correct.
So is this when you say that this is part of the brand, and you also earlier testified that they've been doing this for 20 years, did you observe any times before you purchased the assets, did you observe the outdoor, let me put it this way, did you observe the merchandise on the outside of the building?
Yes. I mean, we obviously, as part of the process from the time we decided to buy the business through the many months it took to get to the stage of actually buying the business, we went by all 4 of the stores many times. And many times there would be furniture, at least some items outside, sorry.
And were you advised that there had been a code enforcement action regarding the furniture outdoors or the merchandise outdoors?
As far as I recall, not prior to purchasing the business.
And when were you first advised about the furniture?
I don't recall exactly. I don't recall exactly. I think it was sometime in the mid to late spring, but I don't recall exactly.
And was that through your manager?
Correct.
And was the manager the continuation from the prior owner of the business?
Yes.
And so that manager was apparently aware of.
He's been the manager of the store for many years.
For how long?
For many years.
For many years. And just for the record, could you remind us what his name is or her name?
Yeah. His name's Chris.
Craig?
Chris.
Chris. Do you know his last name?
Yeah, McCall.
Okay, and I do recall from reading the prior special magistrate's orders that Chris McMullen, correct?
Yes.
Was in attendance representing the landowner / business owner at the time.
He was not representing the landowner. He was there on behalf of Tigre Green Courts, as I understand it. I wasn't there. I don't know anything about it other than what he's told me.
Did you purchase the business assets from 1121 North 3rd Street, Inc.?
No.
Property owner?
No.
Okay, just again, for tell me who you purchased the assets from?
Yeah, oh yes, I can, there's an absolute and clear separation. I purchased the assets from T. Gregory Imports, which is the company that was owned, or that still is, as I understand it, and has been for decades, owned by Todd Gregory Whitten. And T. Gregory Imports, Inc. was a tenant in the building for many, many years. I don't know when 1121 North 3rd Street purchased the property, or how long they've owned it, or any of that.
Okay.
But as far as I know, T. Gregory Imports has always been nothing but a tenant in that property, has never been in any legal way associated with the owner of the property other than as a tenant.
And just,
That's my
I
understanding.
didn't quite catch the name of who the prior operator was.
Of the owner of T. Gregory Imports?
No, was it T. Gregory Imports Inc. was the
Correct.
prior owner of the
Yes.
asset, of
Of
the
the business,
Okay,
not of the property.
okay,
It's always been a tenant of the property.
okay, thank you.
Mr. Tringle here would know better about the property. I don't know any of that history.
That's helpful to me.
The business has always been a tenant, and the owner of the business has not been the same, as far as I've ever known.
Okay. Is there anything else, Mr. Cole?
Sure. So I'd like to present these two pictures. And I would also like to present the pictures of our other business. May I approach? Do you want to see these before I approach? This is our store with a sign, a welcome sign, and a chair that is,
And are they
we
dated,
discussed last time. This was taken last week.
all of them?
Yes, correct. Actually, I said the last 2 weeks, I'm sorry. These two pictures were taken just prior to the last year, because I think they happened at the last year. So these two pictures, which I just printed in today, were taken just prior to the last year. To show, one, what the store looks like with a chair and a sign and a flag. And the other to show what it looks like without any of that, and which is supposedly in compliance with what the city's demand is. One looks welcoming and inviting and in violation of nothing, and it's not the business of advertising. The welcome sign is not the business of advertising. A sandwich board saying welcome in is not the business of advertising. The chair, even if it happens to be for sale, is not the business of advertising. And then this is what the city would have the store look like, which looks closed, which our customers are not telling us will look closed. And our business is down significantly compared to the same period of time last year. This is our store in Ormond Beach. Similarly, a couple of few chairs and a very conservative, nice sandwich board outside. It's the brand. This is our store in St. Augustine, same thing. A couple of chairs and a sign. People sit in these chairs. Sometimes spouses will sit in the chair while somebody else is inside shopping. It's a convenience to our customers. It's welcome. It's a convenience to our customers. And it is not the business of outdoor advertising, even if someone might try to construe it as advertising. It's not the business of outdoor advertising.
And
this is our-
I want to ask you not to testify while you're up here,
Oh, I'm sorry.
okay, because I need you to
Can't hear it.
picking up on the microphone.
I'll leave these pictures. Thank you. Let me check my notes real quick if I could. I made this point before, but I want to reiterate that when enforcement is based on,
Excuse me, these are not marked.
I can mark them in some way
I
if you'd
just
like.
want to, I'm glad to mark them, I just need to know which store is which.
Oh. I can come up there and do that real quick if you like. So I've written in the bottom right corner of each of the pictures that you handed me back, FB for Fernandina Beach, OB for Ormond Beach, and SA for St. Augustine. So one of the things I said while I was up there, to the extent it would be considered, the impact of complying with the city's demand about having nothing outside has been observably detrimental to our business, with a significant drop in people coming in and in revenue. And it is inconsistent with our brand. And so, again, it's not advertising is not a primary purpose or a single purpose. It is also convenience. It is also alerting people that the store is open. It is also being welcoming and showing that we're open, as I just said. I made this argument before, and I know that Your Honor didn't love this argument, but I think this argument is correct and should be on the record, that when enforcement is based on complaints alone, it leads to arbitrary enforcement. That doesn't mean that anyone's necessarily being targeted, but it means that if there's a set of circumstances that constitute a violation, and those set of circumstances are rampant throughout the city, but only one entity or a few are being complained of, then it is only being enforced against those few, and that's arbitrary. And it's arbitrary for many reasons, but it's particularly arbitrary because it's neighbors that are deciding when and how the city enforces ordinances, as opposed to some sort of regular inspections and those sorts of things. And believe me, I'm not trying to call out other businesses that are acting in a way that I believe is not in violation of the ordinance in the first place. But it is correct that if you drive up and down 3rd Street, there are many sandwich boards and many items of furniture out and about, and many signs and many advertising signs, all of which I don't think are in violation of this ordinance, because the ordinance is about the business of outdoor advertising.
Do you have any evidence of that other than, an allegation?
Your Magistrate, I would like to state that during our last hearing.
Could you just hold
Okay.
the comment, hold all your comments? I'm going to try to do this in order, if you don't mind.
I have several photographs. I do not know exactly when these photographs were taken, but they were taken at some point, I believe, prior to, or they were taken at some point by Chris, who we spoke to, or who we spoke of before, at some point prior to the, was it September hearing or the November hearing, or the hearing that happened
In the fall.
in the fall.
These pictures were
Correct.
taken in the
I
fall.
believe these pictures were taken in the fall. But if you drive up and down the street, this is consistent with exactly what you would see today. So, I mean, if you want. And again, we're not interested at all in calling out other businesses or flagging other businesses and suggesting that they're violating an ordinance that we don't believe is being violated. But these circumstances of which there's an accusation that there's a violation are to be found sort of up and down. And I can show you some, let's see.
Are they identified with addresses and,
They're not identified with addresses, but again, I think that it's my understanding that these were all taken, this was not. What it says. It is my understanding that these locations are in the Jacksonville Beach area and subject to the same ordinance. If they're not, I'm sure Ms. Beavers could explain which ones are not. pictures of storefronts that have similar or other things outside the store, which presumably would be considered a violation of the
How many
ordinance of issue.
photos are there?
I can count them.
And are there repeats or these are all different locations? That you say are in the Jacks Beach area?
My understanding is these are in the Jacks Beach area. I'm not prepared to testify that each one of these are in the Jacks Beach area, but I would ask that Nikki Beavers is certainly welcome to take a look, and if she thinks one of these is not in the Jacks Beach area, she's super familiar with it. And she's certainly welcome to point that out.
Well, it does seem, this is what you're offering to, as evidence of, arbitrary enforcement. It would seem, and quite frankly, taken in the fall of 2023, I'm not sure that it's really how influential, persuasive that evidence is. I'm not going to tell you,
Fair
to
enough.
proffer them to this, this hearing, but, it's a little thin in that we don't know exactly who took them. We don't know exactly if they're in the area, and we don't know when they were taken.
Your Honor, I'm gonna do this instead of presenting those, because again, I really have no interest in
Well,
bringing other businesses into this
Well,
mix,
but-
and I don't mean to do that, so I'm just
but
gonna,
with your allegation of selective enforcement, you either are bringing that allegation or you're not. And if you are, then I think it's appropriate to have evidence and testimony to support that.
so I wanna be clear, I'm not making an allegation of selective enforcement. I believe that selective enforcement is a defense. I'm raising it as a defense, and I'm saying that I believe that the circumstances whereby, which is what Ms. Beavers explained, enforcement is predicated on complaints, leads to arbitrary enforcement, because that means that neighbors can simply complain against one neighbor or a select few, and those are the entities that would be enforced against. So I'm making the argument that the process that was explained to us, which is that this enforcement is not on a complaint by complaint basis, is an arbitrary process. That's the argument I'm making. So a couple things on evidence. I'm backing up, and I really don't want to glaze over this because I was hoping that the meeting would happen. I thought that we were going to have a meeting between May 22nd.
I'm not gonna stop you from testifying, so you get to decide when you're, you've said enough, so, you have said now to me 3 times, I don't really wanna go into this, but then you do. So I'm a little, you're sending me mixed messages about what your position is, what you want to use to defend your position. And I think you need to be absolutely clear so that I can take evidence that you want to present, testimony that you want to present, and make an ultimate decision. But going back and forth, if I'm not really making this allegation, that's not helpful to me in my position as special magistrate. I need to understand I need you to tell me specifically, if there's, what your position is. Now, it's very clear to me that you don't think that this particular ordinance that was cited in the notice of hearing, is applicable to what your business is doing by putting merchandise outdoors. I understand that part. You need to tell me whether you want to make selective enforcement part of your defense. And, because we've now spent quite a bit of time talking about this particular
very succinct. I am making the argument that the process that Ms. Beavers has raised of enforcing this provision on a complaint-only basis is arbitrary enforcement. I am not presenting evidence that there has been arbitrary enforcement at this time. In order to do that, I believe actual discovery would be necessary to see what has and has not been done by the city. So I had hoped that we would have the meeting that Your Honor had recommended, and that we might get this thing resolved without having to dig into that sort of discovery. But in order to really present evidence of that, I probably would need to have that sort of discovery, which has not been part of the process so far. So I'm presenting the argument that the process described in Ms. Beavers, I believe, leads to arbitrary enforcement because it's complaint-based. I am not presenting evidence that they've actually been arbitrary because I would need discovery to gather that evidence. So to circle back, I think that the burden of proof is on the city to show that this ordinance is applicable. And that there's been a violation based on the strict language of the ordinance. And I would ask two things, well, maybe it's three. One, I would ask the citation be dismissed. Because I believe the citation, I'm asking that the citation be dismissed because there has not been a violation of the cited provision regarding prohibition against the business of outdoor advertising. If not dismissed, then I'm asking that the matter be continued so that the parties can have the meeting that Your Honor had previously recommended. Because again, we would like to get this matter resolved in an amicable fashion. If we're unable to do that, then I would ask that we be granted an opportunity or time period for discovery.
What was the last one?
If we're not able to reach a resolution, then I would ask that we be granted some time period for discovery. And if you continue the case, I think we should be allowed to resume having some items outside, because another delay in the case is hurtful to our business. And I think we've shown that the violation is, or that the provision is not applicable. But again, no, I won't repeat myself. Thank you.
And with that third one, actually, I guess, fourth, request, because the first one was citation be dismissed.
Yes.
Second, matter be continued to allow for the meeting with staff. Is this correct?
Yes.
Three, allow a time period for discovery.
In the event we're unable to resolve it through an amicable meeting. That's right. I don't want to.
I'm good.
Yes.
If no resolution, through meeting. And four, allow you to resume having a merchandise outdoors. Would that begin, when do you think that should begin?
I would request that it begin right away. We've paused out of respect for the process.
And then
But-
what merchandise, would you say, a chair?
Along the lines of the photograph that I showed you, yes, a chair, maybe two chairs, a chair, a welcome sign, and the welcome flag. I think this is what we talked about last time.
So you mentioned the photograph. The photograph shows one chair, it shows a sandwich board, it shows a welcome, I don't know what I would call that a welcome banner. And then it looks like some wreaths and flowers on the front door.
Yes, I think Ms. Beaver said last time that those wreaths were not a violation. So it would be those other items, and I think,
So it would be the three things, it would be the sandwich board, the welcome banner, and a chair.
yes, and while I don't think we should be constrained in that way, I think that would be an acceptable compromise in the interim until this is resolved, with the hope that we reach some amicable resolution before we have to come back. again, step one, though, is I think the citation should be dismissed for the reasons I said. But if not, then we should have an opportunity for that meeting under the circumstances that we just described.
Okay, is there,
I think that covers what I want to present. I guess I'll hear what else. I'll hear what else the city has to present.
thank you. Back to you, Ms. Beaver.
Thank you.
You earlier had a comment.
Yes, my comment was gonna refer to the photographs that, he has. If you go down 3rd Street, the reason why none of those businesses have been here or here today is because all of them were cited and have all come into compliance. So the bicycle shops, the Moss store, I'm looking at the pictures as he was going through them, and every single one of those businesses were cited, and those were the pictures that Chris presented back in the fall when he was initially cited in September, and they all have come into compliance. So, that's all I was gonna say.
Okay, thank you.
In regards to the meeting, I was told would not be necessary, it would be heard today, and that's why the director, and the planning department, they are all here today to testify to explain why the city has that ordinance and interpret that ordinance.
Okay, are you ready?
Yes,
For that?
Yes.
For her to testify?
yes, Heather and Christian both are here.
Please raise your right hand and state your name and address.
Heather Ireland, Planning and Development Director, 11 North 3rd Street.
Do you swear or affirm that the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Your Honor, may I approach and provide you with a copy of this memo before I discuss it?
Yes, and do you have a copy for, Mr. Pope?
No, but I can give him my other copy after I'm done talking to it, if I can bring it to you.
Can I see it before you present it?
Um,
I'll give this copy.
I wanted to say thank you very much for being here today. Even though I don't need, I do appreciate the city's attendance.
Great, thank you. I would like to just start by talking a little bit about our code enforcement program. We've got almost 3,000 businesses in the city and 12,000 plus properties and one code enforcement officer. Officer Beavers is very efficient and very effective, but she does not have the capacity to drive the city and look for violations all day, every day. She responds to complaints, and if she notices something while out in the field, she will address it at that point in time. I'll give you an example. If she sees a flutter flag, she's all of a sudden going to see 20 flutter flags because it's now something that's in her mind. So kind of wanted to point that out, that there's certainly not selective enforcement. It's as she can get to it, since she is a party of one and very good at her job at that. This memo that I've put together to present to you, I drafted in coordination with our city attorney. Essentially what it says is that our zoning code and our zoning districts, if you see kind of halfway down the page, section 34, 31, 16 states that the exclusivity of uses in zoning districts, the permitted and conditional uses in the zoning districts established in Article 7 zoning districts are exclusive, you'll see that in bold, and are permitted subject to the other standards of the Land Development Code. What this is interpreted by myself and the previous two directors is that in our zoning districts, if it is listed, you can do it. If it is not, you cannot. So in all of our commercial zoning districts, the use of outdoor display and sale of retail merchandise is not permitted. There's no negotiating that fact any more than there's negotiating that a bar can be allowed in a residential zoning district. If it's not listed or doesn't fall under a use that's listed and we're able to put it in a box, if you will, it's not allowed. And so that's where we fall into, it's not listed in C1 zoning, it's not allowed. There are some exceptions in our commercial planned unit development zoning, namely the ones that contain Ace Hardware and Home Depot. Those are specific zoning districts for those properties. They do allow outdoor display of retail merchandise with some limitations in both commercial shopping plazas. So they do have them. We do hear from other people a lot saying, why can't Home Depot have it? They have a special zoning for their property, and they're allowed to do it. Same with Ace Hardware. Same goes for seasonal items such as fireworks. I'm looking at our clerk over here because she probably knows better than I do, but fireworks, I think pumpkins, Christmas trees, and firewood are seasonal. They're allowed to be outside. And right, and then businesses are allowed to get 6 tent event permits per year to do, you know, special, Sportsmania, for example, does it for Florida Georgia weekend and some of the Jaguar games. So we do allow special events to go on for special sales, special things like that. But essentially, what it boils down to is if the use isn't listed, which in this case it's not, and again, there's no negotiating that, it's listed or it's not allowed. It's really as simple as that.
I appreciate that very much. The issue that Mr. Poe has presented is that the notice of hearing cites to a very different ordinance provision.
Yeah,
It does not
see
cite-
that.
It does not cite to, you know, 34-3116. It does not cite to outdoor display and storage of merchandise. It is a citation that it's a violation because the language in the code that's referenced in 342 is the business of outdoor advertising.
Right.
it- I definitely, let me ask you this, is there a provision in the code that speaks specifically to the use of outdoor display and storage of merchandise?
There was an original citation, and we were told that that
Wait,
was not correct.
Got to,
Mhm.
I can't,
Okay,
I
okay, I'm
can't
sorry.
go back and forth. I'm talking to Miss Ireland right now. I mean, you're welcome to talk with her if you wish, but while I totally understand the memorandum, where is the provision that says that outdoor display and storage of merchandise is, or maybe there isn't one? Are you saying there's not?
There isn't, that's exactly what I'm saying, there isn't one, because it's not a listed, permitted, or conditional use, it's not allowed. So I can't speak to
Would it
the,
be more appropriate for the notice of hearing to have cited the fact that it's outdoor display and storage of merchandise, and that is not a permitted use in CPO?
perhaps,
And
yes.
therefore, it's a violation. And cite to 34-3116.
I have not seen the notice, but yes, I would agree with your assessment of that. That is the provision, just like I use the reference or example of a bar in a residential district, not a listed use that's allowed, can't do it. Since it's not listed, you can't do it. Same thing with outdoor display of merchandise.
Right. And maybe there's even a section in the CPO description that says, these are the only permitted uses. I don't know. I haven't read your code.
That is how our zoning district works. In every zoning district, there's a list of permitted uses and a list of conditional uses, and those are the only uses that are allowed in that zoning district. There's no real wiggle room, with a few exceptions. Business office, for example, it might list several different types of business offices.
Right, right. You know, I'm concerned that if I find that there's a violation of 3042K that says outdoor business, the business of outdoor advertising, have you looked at your interpretation of what that means? Mr. Poe presented quite a bit of evidence about what that 2015-8065. Oh, I think that in that ordinance, that's where the language for the prohibition against the business of outdoor advertising is added to each zoning district. Do you have an opinion on that, or are you prepared to?
Yes, I do,
comment like that?
and I do agree with Mr. Poe. That is my interpretation of the intent of that section of the code. Unfortunately, our code does not have a definition of outdoor advertising for some reason, but that is my understanding of the intent of that when that section of the code was rewritten. It does not negate the fact that outdoor retail display or display of retail merchandise is not an allowed use. It's not that it's prohibited, it's strictly not allowed, since it's not a listed use.
Would you bear with me one moment, Ms. Arlen? Ms. Beavers, is there anything that I think you wanted to say something.
No, there's nothing else.
You're okay now?
Yes.
Okay. I'm presented with a conundrum. I have a notice of hearing that cites just two provisions. The general provision on CPO, and which is 34-341, and then CPO 34-342K, prohibited use, the business of outdoor advertising. This is a conundrum. I understand that the city's position is that outdoor display and storage of merchandise is not permissible. But I don't think that that is what the notice of hearing. I think there's two ways to go about this. The city could withdraw this notice, and I could then issue an order that says that the city has withdrawn and the case is closed. I could also issue an order that says that something along the lines of explaining that outdoor storage is not a permissible, outdoor display and storage of merchandise is not permissible. However, the notice of hearing didn't cite to that, and therefore I'm dismissing the case. Or you could meet with Mr. Poe and try to come to a resolution and determine whether or not there is, whether Mr. Poe would be willing to get one of those special permits for the.
The tent permit that's 6 times a year, that would be my only recommendation. That was recommended during our last hearing.
I could continue until our July hearing. You've heard what Mr. Poe has suggested. He would like to cite initially, and probably his favored position would be the citation would be dismissed because it's not technically a violation of the provision that was cited to in the notice of hearing. So, you know, I'm more than willing to, have you, you know, confer in a corner, if that's what you'd like to do. You'd like to take a 5-minute recess, that's fine with me. But I am in a conundrum, and I want to find a resolution that, you know, puts the city in, and quite frankly, both parties, but, puts you in the best position of moving forward. It could be that you need to withdraw this and then proceed to issue, if the behavior continues, issue a notice of hearing, a violation based on the correct code provisions. So that's where I am right now. You tell me if you'd like to, you know, take a 5-minute recess, I'm fine with that. And so that you can discuss this, and then I'd appreciate if you come back and let me know, your thoughts.
If I may,
Yes, Mr. Cohen.
I think that with the acknowledgement that the cited provision is not applicable, the citation should be dismissed. That said, and without the, you know, the hammer of this proceeding hanging over anybody's heads, I welcome it and would love to separately have a meeting with folks and figure something out.
Well,
Maybe.
what I'm gonna recommend is let's take a 5-minute recess. Let the city confer, and then we'll come back. Okay, thank you very much.
after consulting with my colleagues, we would like to request if we can amend the notice to properly cite the code.
Okay, thank you very much. Mr. Foley?
I would like to ask Ms. Allen a couple questions.
For, I'm
Yeah,
sorry.
I would like to ask Ms. Allen a couple questions. If this proceeding's not concluded, I'd like to ask her a couple questions, and then I will have a response for you. May I? Ms. Allen? Is that okay?
Well, I would have preferred if you had questions that you would have asked them before, but
Well, for one thing, Your Honor, I thought that you had said, again, for us to confer, and then the city would have to get out of the room.
you're gonna have to get through the
Yeah.
microphone.
For one thing, it was my understanding when we just broke that there was some expectation that the parties were going to confer, but I was not conferred with at all. I'd like to just ask a couple of quick questions of Ms. Ireland to understand that I think shed the light onto the request that they just made, if I may.
Yes.
Ms. Ireland? Nice to meet you. You and I haven't met before, is that right?
No, I don't think so.
I can't tell you how sorry I am that we're meeting under these circumstances.
No worries, you have me till 4.
Yeah, understood. I'll be very quick. This is the memo you presented, is that correct? You prepared this memo on June 20th? Did you start it on June 20th, or how long do you think it took you to do it?
Oh, I can't give you an exact date.
Sure.
After, and I'll speak into the mic so it's on the record, after the last hearing, so sometime between that date and after the last.
May 24th, is that correct? And that email from Nikki Beaver says, please see the request below from Mr. Poe, is that correct?
Yes.
And that is Nikki Beaver's forwarding to you the email that I sent on May 24th, that same day, asking for the meeting that the judge had instructed us to have, isn't that correct?
Yes, that's what I'm reading. She recommended. Is that
I'd like
correct?
to present that to the judge, if I may.
Sure, I'm not exactly clear why it's
I'll make,
relevant at this point, but
I'll try to make my point. Just a
other
second.
than,
I'll try to be brief, and I'll make my point. If I may present this to you.
yes.
I have that email up here.
I have one other email that I want to ask you about.
That's it.
Ms.
Oh,
Harlan,
It's not the one, yeah.
Okay.
one other email I want to ask you about.
Okay.
This is an email also from Nikki Beavers, is that correct?
Correct.
And this email is dated November 14, 2023, is that correct?
Yes.
And this email is to Loraya, I'm not sure I'm saying that right, and you're CC'd on this email, is that right?
Yes.
Did you receive this email?
I received it, doesn't mean I read it.
Okay, do you recall, this was,
I get a lot of emails.
so this was an email concerning the subject case back in November of 2023, right? And what it says is, it's from Lauren saying, I was looking over the notice of hearing for 1121 North 3rd Street and noticed that the code sections violated are different from the last agenda. See below, did they change? And then Nikki Beavers responded on that same day and said, if you agreed that.
Yes, it says, this is from Nikki on November 14th, it said, this particular case has been unique and challenging at the same time due to the wording of the existing code. I sat down with Heather, and I think it meant to say Christian, but I apologize, she called you Christina, and it was determined that this was more appropriate violation to cite.
It was more appropriate, what?
A more appropriate violation to cite.
And this was concerning the hearing that we've been talking about that led to the prior order, is that right?
I assume so, I can't speak to that because I don't recall any of the
Okay.
emails.
Okay. So this would have been the
Especially
other
over a year
page of
ago.
that email, is that right?
Yes, it appears to be.
This is the correct case number, is that correct?
I don't know.
You don't recall?
No, I haven't seen the agenda, I don't know the case number off the top of my head. 130?
Yes,
That's correct, per the code enforcement officer, that's correct.
I think that's my questions at this time. May I approach you? Oh, let me ask you, as far as you know, there hasn't been a notice to the landowner or to T. Gregory Imports citing the provisions that you mentioned in this memo, is that
I
right?
would have to defer to Officer Beers.
What are the provisions that are,
May I approach, I'll present this to you. the argument I'd like to present based on what I just presented is this, in response to their request to amend the notice of citation. One, we have not received until today notice of citation that they're talking about in the memo. Two,
What is the reason?
okay, I'm sorry if that's not clear. I object and disagree with their request to amend their notice of citation. And instead, I believe the citation should be dismissed. Here's why. There's been no notice up until today of the provision that they now contend they're relying on. Two, as that email makes clear, as far back as November 2023, they were aware that there was trouble, I think was the word in the email, with the language of the provision that they're relying on. Three, on May 24th, Your Honor instructed/suggested that the parties confer and try to work this out. I reached out to Ms. Beavers, as that email shows, within 2 days. And she immediately forwarded it to the other city folk, the other folks, including Ms. Ireland. My email asking for that meeting. Instead of having that meeting, they began preparing this memo, which they concluded 6 days ago, on June 20th. I never got contacted. I reached out to Ms. Beavers twice. I never got contacted. It's not that they didn't know. They had the email that I requested the hearing. And it's not that they weren't thinking about it. They were visibly preparing the memo. And so now, here we are, the day of, and I've presented what Your Honor, I think, recognizes is a correct argument, that what they've cited is not applicable. Ms. Ireland has acknowledged that what they cited is not applicable. It should simply be dismissed. And then, hopefully, the parties can get together and work out whatever we need to work out without the hammer of an order or an amended citation hanging over our heads. We've spent enough time on this. I presented very good arguments, basically acknowledged arguments that the citation at issue is not applicable. That citation should be dismissed. And to allow amending it now simply prolongs this process, which we could deal with without a citation hanging over the heads.
Well, I think the city has the right to amend citation. And I think, quite frankly, that's probably the best option based upon what I've heard. There's nothing that prohibits them from amending the citation. Yes, they could dismiss it or they could withdraw it. I could dismiss it, but actually dismissing it doesn't really address the issue at hand. And the issue at hand is that you have outdoor display of merchandise that is not an allowed use. And according to the photographs that you submitted, that's merchandise that, you know, and then if there is one for the welcome banner, then I would expect to see something on that also. But as far as the, you know, it does appear, and I'll let you make your case, that it's not outdoor display and storage of merchandise. But I mean, you have even said that these items are for sale. It may be that there's also just as I have today. And just as I asked the hard questions about this particular notice of hearing. Just like in a court of law, a plaintiff has a right to amend a complaint. And I can't see I've heard nothing, no testimony that would lead me to believe that the city is prohibited from doing that. And so I think that that is the right outcome here. I think that whether it turns out to be that it's not outdoor display and storage of merchandise, or there's not some other provision that they're going to cite to, I don't know their code as well as they do. And you wouldn't want me to, quite frankly. I don't want to. But the fact is that they have said to you that they agree that it's not the business of outdoor advertising. They should have a right to get it right and look at what the evidence is, and then look at their code and be more specific. Just like an amended complaint. I mean, I don't know a judge in the world that doesn't give a plaintiff an opportunity to amend their complaint.
So I don't recall, because it's been a while since I practiced in Florida, the exact rule on when it's permissible to amend a complaint. I'd have to do research on that, but my understanding, my recollection is, and if this is wrong, I'm sure Your Honor will correct me, is that it's permissible up until the time of trial. We're here at trial. I think it's too late to do that. And I think that under the circumstances, when, quite frankly, they were aware of this issue and could have met with me and given me notice of what they intended to present today, and didn't give any notice of what they intended to present today, that this matter should be dismissed.
Mr. Poe, I encouraged the parties. That was it. There was no instruction on my part. There was no mandate on my part. That would, quite frankly, be outside, in my opinion, outside of my role. I don't have the right to force mediation like a court of law does.
I agree, Your Honor.
So it was a simple encouragement. So this idea about how, even the emails, I want to meet, and somehow I've been, hurt because, or disadvantaged because they won't meet with me. I can't. I believe that they probably have an incredibly busy schedule. And if they think that they can address an issue, it's not mandatory that they meet. Even if I encourage it, it's not mandatory. So, I'm not going to say, oh, city, you were bad because you didn't meet. No, I'm not going to do that.
I'm not.
So I am going to rule that this matter is going to be continued. I'm going to continue it for 60 days. I'm going to allow the city to amend their notice of hearing and cite to the provisions that they think are applicable. If you have similar arguments about those new code provisions, I think you know that I will listen to you, and I will listen carefully, and I will pay attention to the very specific language in those code provisions. So I think it's an appropriate and a fair outcome, and I appreciate everybody's time. I feel that a tremendous amount of resources, mine, yours, Mr. Trent
about to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
And can you please state your address for the record?
4711th Atlantic Beach, Florida.
Thank you.
And you're here on behalf of the property owner?
Correct.
Thank you.
Correct. And this is directed to the property owner. Are we gonna amend that portion too for it to be to the tenant, or do I have to be involved?
I think that's a very fair question. I know that rather than saying what I think I know that Ms. Beavers, I believe that the rule is that it has to go to the property owner.
And the tenant, it would, both are cited.
Say again?
Both are cited, the property owner and the tenant.
And would you be thinking that you would be doing it to the property owner and the tenant this time?
For the container.
for the
Yeah, that's
container?
always the rule, that both property owner and tenant are cited for the violation.
Okay, well then, I know that this one was just addressed to the property owner.
Well, we cite who is on the tax appraiser's website. And that is 1121
Right,
North 3rd Street LLC. So they get properly noticed, as well as the actual business itself. And the address,
well, I think that it would be important to.
both are cited.
To name both entities in the amended notice, specific.
Well, both get a notice. One gets a notice, one notice goes to 1121, and then the notice also goes to T. Gregory Imports. So both are noticed on the notice of hearing that they get. But you're saying they both should be listed on each notice?
Well, I've never for instance, in the information that I received, which is the notice of hearing,
Yes.
the only notice of hearing I have received is the one that is addressed to 1121 North 3rd Street, Inc., which I believe is property owner.
The property,
Correct,
correct.
Mr. Kendall.
Yeah, T. Gregory also gets one. I always do one to both. So we'll get that, I can get that copy to you.
Okay, and in this case, since we know that who the business owner actually is the Pink Moon, no, hold on.
So the name that he stated earlier, there's nothing on the property appraiser's website that lists that name
Right, but we have,
as the registered owner.
have sworn testimony that he did purchase it, that Pink Moon Imports LLC.
Yeah, on the property appraiser's website, it does not list that.
No,
It
it's,
wouldn't
it-
list it because we're the tenant, it's on the lease.
Yeah.
Pink Moon Imports is just the tenant, it wouldn't be on.
he bought the business, not the
Right.
building.
If I
But-
could say,
But for the property is
What about your business?
owner.
Well, this is a good discussion. What about your business license?
the business license, does not have the complete name because there was a space constraint. I don't remember exactly what it got shrunk down to, but it doesn't have the complete name of the business because of the space constraint.
Well, what does
Monica
it,
was very nice and helpful.
what
I
does
don't remember exactly what it says.
is Pink Moon listed on it at all?
I think it says, I actually think it says T. Gregory Imports DBA, or DBA, I think it says DBA T. Gregory Imports, because it is
That
Pink
makes
Moon
sense.
Imports DBA T. Gregory Imports.
Okay.
But if I may, Your Honor, that's yet another reason that instead of.
Mr. Bloom, I'm so sorry to interrupt. May I have you just step a bit closer to the microphone?
Again, Your Honor, I would say, that's yet another reason. Instead of doubling down on this mess, it should be dismissed, and they can start over and do it right. If we put something out there that they think is a violation, they can issue a violation correctly with the right citation.
Thank you, I understand your position. Mr. Popoli?
Yes.
Please raise your right hand and state your name and address.
Christian Popoli, Senior Planner, 11 North 3rd Street.
Do you swear or affirm that the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
I just wanted to offer a quick clarification.
Thank you.
The section of our code dealing with code enforcement specifically states that the notice of violation will be mailed to the owner of record and the person responsible for the violation, which in this case would be the property owner and the tenant. Our notice requirements under the general code specify that we will use the current address as listed on the Duval County property appraiser. So if that hasn't been updated, it's going to go to that address whenever we issue anything under our notice requirements.
Okay, what I would suggest is that in light of the sworn testimony, we know, and you know, that and you have a business license that says Pink Moon, blah, 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 doing business as T. Gregory.
I think it doesn't say Pink Moon, I think it just says DBAT Gregory Imports. That's my recollection, I don't have it in front of me, but that's my recollection of it.
Well, who is doing, I mean, you can't just say DBA.
You could probably call
It
it.
has to be some
Pepper.
entity doing business as.
I agree, it was disappointing that.
Let me ask you this, just for the record. Is it Pink Moon? You've already testified that Pink Moon is the tenant, is the operator of the business, and you're doing business as T. Gregory Imports.
That's correct. Pink Moon Imports LLC is the.
Okay. So, based upon that,
We can certainly over-notice to make sure we capture everything.
thank you very much. Okay, so.
And then just as a final point, any fines that are accrued through a code enforcement action can turn into liens, which are subject to the property owners. Ultimately, the property owner is going to be the responsible
Which is
party.
why we have to name
Right.
property owner. So the city will, when I say we, I mean the city will have to continue to name the property owner,
No problem.
but, and if fines were levied and not paid,
Right, then we'd be responsible.
yes,
Yeah, I got it.
so.
Thank you.
Okay.
Last point for me is, with this being retail of like the furniture and housing finishes type, I would say in terms of the construment of what is actually advertising, because if it is a couple seats that end up being seats that are out there that they don't sell in the store, they do sell in the store, but those are the ones for their customers, and some vases of flowers, and some things that are outside that are useful that, in my opinion, that shouldn't be construed as advertising if it's still providing a service to the customer. It's just like a bike shop having a bike rack out front and saying you cannot have bikes in the bike rack out front because that's advertising. There's a fine line here where I feel like you guys need to get to. That's my 2 cents. I don't know. I have to say that on the record. So that's all I got.
Thank you very much. Ms. Ireland.
I just wanted to offer that I will send directly to you, Mr. Poe, our policy. I know Officer Beavers has mentioned the city policy where you can do 6 events a year. We have a lot of businesses that use that. I will be happy to send that directly to you and a copy of the permit that's required to do that. A lot of businesses take advantage of that. It's not in our code, it's a policy, so council has kind of blessed it, and so we're going to continue with it. It's basically, again, 6 events a year. It works really well for some businesses to have these special events when they're doing whatever it is. Might be related to something else going on, might not be. But that is the path forward if they want to move some merchandise outside a few times a year to have these special sales or events or what have you. I'll be happy to provide that information so that they'll know what they need to do. It's a really simple process.
Okay, thank you very much. I think that we're done. At the risk of getting back into it too much, is there anything else that Mr. Evers or Mr. Poe want to say?
Just want to clarify that we're coming back in 60 days,
Yes.
and
And what I believe needs to happen is that the city needs to promptly, and I might say, within 21 days, issue the amended notice of hearing. And Mr. Poe, that would give you
so I
I
would like
did,
more
I
time.
did, what
I
I was
would-
saying, well, remember, what I was saying was 60 days from, 2 months from now.
Understood.
So if I give them 21 days to issue, that leaves you 40 or 39 days to prepare, approximately. It's not exactly 60 days,
Are you, so 21 days to send a notice to me, and then from that point, I would have approximately 40 days before the hearing would be, is
Yes,
that what you're
I
saying?
think it boils down to, I can either say we're gonna have another hearing in 60 days, or I can say we're gonna have another hearing in 90. I want to be sure that, that you feel that you have enough time, either with because I think 21 days is probably appropriate for the city. So you tell me, do you want?
Can I make a suggestion? I'm fine with the 21 days for them to issue a new amended notice. I'll say this, I disagree with it being amended at all. I think it should
I
be
know,
dismissed, but
I
I'm just
know.
on record saying that. But as far as to the extent you're doing that, I'm fine with the 21 days, and then I would say that a hearing would be had, not less than 40 days after the issuance of the amended notice. Is that, would that work?
Well, I'm gonna set.
You're gonna set a date?
Could you check, Monica, what is the date of the August hearing?
The 21st.
So actually, maybe we should just do the September, because August 21 is less than 60 days from now. Today's the 26th.
So
But I would say, instead of saying 60 days, I would say the August hearing.
Well, but that becomes even less than the 40 days that, if I give you 21, then, I'm trying to be very fair to Mr. Poe to prepare, whatever he thinks, in whatever fashion he thinks that he needs to prepare. In light of the fact that I am going to allow the city to amend, and he should have time. So I think we should just set it for September. That way, there's no question, in my mind anyway, that there's adequate time. What is the September date?
The 25th.
Okay. September 20th.
One other comment, it's a request. It's my understanding that you're going to continue the hearing, you're going to enter an order continuing the hearing, allowing them a certain amount of time to issue an amended notice, and then it's going to schedule the continued hearing. I would ask that the order not make any findings of law or fact, but just continue with those, instructions. Because this is the first I'm seeing of this provision, and it's only a partial quote of the provision. I don't think it would be appropriate for the order to include any findings of law or fact.
And there may be others that they have.
Sure.
I mean, I'm not limiting them to what they're going to amend. I'm not limiting them at all. So there could be others, Mr. Cohen. So I'm going to give them 21 days to amend, and then we're going to have the hearing on the 25th. And I will, I'm sure that I'll probably make some findings based upon today's discussion and testimony, and then I'll conclude that the hearing is going to be continued. So I don't think there's any other questions. I appreciate everyone's attention and time.
I'm sorry, I'm just looking very quickly at my schedule, if that's okay, Your Honor, to see if there's something on the 25th. I don't think there is. Thank you.
Did you say you were looking at your
Oh,
schedule?
I'm sorry, I didn't. I was looking down at my phone, and I wanted to let you know what I was doing. I was trying to make sure that the 25th was clear.
And is it?
It looks like it is.
Okay, great. Then I think this matter is concluded. The hearing's not done. We still have two, but thank you very much, and
excused? Thank you for your time. We're excused?
Pardon?
We're excused?
Yes.
Yes, thank you.
Okay, moving on to, next on the agenda, B, this is case number 2362, HCA Investments LLC, violation of addresses 412 North 7th Street, Jacksonville Beach. This case was a continuance for, not obtaining a building permit for a outdoor shed that was constructed. Mr. Middlebrooks was present today, but he had to leave. We did have a discussion, during our brief, break, and, once his final inspection is completed, we'll then come back. So he's done everything that he was supposed to do in regards to obtaining, the permit, getting the structure moved. So once everything is finished and his final, inspection and the certificate of occupancy has been obtained, we'll then come back to close the case.
Do you want, I know that our last order was that he had until today to obtain the final inspection and a certificate of completion from the city.
Right, so I was advised by the building department that with his active permit, that he does have 180 days from the date that the permit was obtained. So, the city has to allow that.
And when will that expire?
I don't have the exact date. Mr. Middlebrooks he was gonna stop by the, planning and zoning department and get that exact date and make sure that everything is completed, and the final is completed at that time, by that time. But he's on the roll, and I'm sure he'll have everything done.
Is there, I'd like to have the order reflect that instead of going
Okay.
every month like this.
No, we're not coming back. We're not gonna come back every month. We're gonna come back once the final has been completed.
But there should be a deadline.
The deadline is the 180 days.
Okay, but we don't know.
Right, because I don't remember if I had it in the notes from our last hearing.
It's 180 days from the date the
That he
building.
obtained the permit, and let me see if I have, no, I didn't write it on here. I probably had it in some notes that's in the office, and so he wasn't sure of when those 180 days would also expire, so he was stopping by to get that information before he left.
Okay, I'm looking at it.
But I will put it in before the, order is completed, I will get that to the clerk's office, and then they can forward that information to you.
Okay, I will, okay. Okay, that, I can draft the
Yes,
order.
I'll get that to the clerk's office
If
today.
you can get the clerk's office,
I'll get
the
that today.
date, that would be great. Okay, we're done with ACA.
Yes, and our next, case is, case number
Well,
20.
but one more thing.
Uh-huh.
If for any reason he did not have the final inspection, and is it a certificate of completion? or
Yes,
is it
it's a
certificate of-
That's a certificate of completion.
Okay, if he didn't have that in this order, because the order's gonna say he has to have it by whatever 180 days is.
I believe he would have it because everything else has been done. It's just a matter of scheduling now.
Okay,
So, because he's done everything else. He's
okay,
gotten it moved, and it's just more so a matter of scheduling.
I think I will put in a provision that says that in the event that it's not completed,
He could file for an extension.
yeah,
Okay.
or that code enforcement will bring it back to.
Yes.
Well, I guess what you would be doing would be setting it for hearing again.
Yes.
Okay, thank you.
And to case number 22-603. This was in regards to no active permit for a shed that was built at
Right.
620 South First Street. This was the initial shed,
Yeah.
then, as you can see, is there a pointer on here? Well, there was, it's in between the two, the leaves and the tree, but that was the remaining of the shed. I think last time it was up, there it is. This right here is the remaining of the shed.
Right.
And as of June 7th, that shed has been removed. It's no longer. So